thank you for mentioning that you're in the process of setting up a trust, because the only time we've heard about trust, even, outside the Kenyan context, is usually with the very high net worth families, the politicians, the Bill Gates of this world and what have you.
Yeah.
And I'm not saying that you're not a high net worth individual.
I am not.
But for you to mention that you're in the process of setting up the trust, I think already it's really demystifying who trusts are for.
Trusts are specifically very good for people who, number one, want to protect their assets. Number two, you have beneficiaries. If you have minor children, if you have vulnerable beneficiaries, and by vulnerable beneficiaries, we mean beneficiaries who maybe have special needs and who maybe have physical or mental disabilities and need long-term protection. Number three, if you really don't want to deal with the succession battles, if you don't want to go to court, if you don't want to deal with probate, then you can also set up a trust.
You have mentioned the word probate a couple of times. For anybody who doesn't understand, what is this probate thing you are avoiding using trust? Coming up with the inventory.
The inventory.
You can actually, that's the first battle people that need to go to court for the succession process have to battle with, because where are the titles? Where is this land located?
Exactly.
What bank accounts did this person have? And you can go from one bank to another saying, Ebu, check this ID. Do you have any bank accounts, with this ID number?
Exactly.
So, yeah.
I think something that people worry about is if I go to a lawyer, they will quote a huge amount.
Yeah.
I think it was yesterday you were telling me about this lawyer who is asking for 120 million
in a succession
case. The thing you need to ask yourself, and the balancing here is, if I pay this fee that the lawyer is asking for me right now, and compare with the pain and the inconvenience of succession if you don't do this, if you don't set up the trust right now, an estate might be depleted at the point of succession because of the high legal fees.
Many people have heard about the Njenga Karume Trust.
Yeah.
Many people are aware that at some point, Njenga Karume set up a trust, and at some point it was embattled and there was a court case. So if trusts are this good, the way you're putting it, and they are meant to avoid all these disputes and what have you, how comes the Njenga Karume Trust ended up in court? And what can people do to avoid setting up trusts that go the Njenga Karume way? Yes. Hi, welcome to our YouTube channel, people of the internet. My name is Wamuyo Kanyere. I am an advocate of the High Court of Kenya. I and my friend here, who will get to introduce herself, we run a firm called Wanjiko and Kanyere Advocates LLP. It is based in Nairobi, Kenya, and we offer estate planning services. We're going to talk about a lot more about it, but this has been such a long time coming. Oh my God.
Right?
Anyway, so welcome to our first ever episode. We are going to offer a lot of value. We're going to have so many discussions about estate planning. So think about everything to do from wills to family trusts, power of attorneys, and everything around that. We're going to, bring you a content that I'm sure you will like. So for now, we are just introducing ourselves. I'll let my friend introduce herself, and then we will jump right into today's video.
Hi guys, it's really nice to finally do this. My name is Wanjiko Mushoki. I am the Wanjiko in Wanjiko and Kanyere. And I'm also an advocate of the High Court of Kenya. Wamuyo, can you tell us why do we call ourselves advocates of the High Court of Kenya, by the way?
This is funny. This is fun facts. I only found about this a few days ago. So advocates in Kenya are called advocates of the High Court of Kenya, and not advocates of the Supreme Court or advocates of the Small Claims Court, for that matter. And the history of it dates back to the colonial times, when high courts were the most prominent courts in the country. Magistrates courts used to be of a way lower rank, and sometimes the people who appeared before the magistrates courts didn't even need to be advocates. And of course, back then we didn't have the Supreme Court. The Supreme Court came with the 2010 Constitution. Again, we didn't have this the Small Claims Court. So there was just the High Court being the prominent court, and of course the Court of Appeal being the appellate court. Now, the Registrar of the High Court is the one who kept a register of the advocates who would be admitted. So every time an advocate is admitted, they had to go sign that roll. It's literally a physical book. We signed it. Every advocate has signed that book. And so that's how the term Advocate of the High Court of Kenya came to be. Fun fact.
Yeah, that's a very fun fact. Yeah. Thank you for teaching me that, actually. Anyway, yeah, we are really excited to do this. And yeah, we'll get into estate planning much deeper. And yeah, welcome to the journey.
Okay, now this being the first ever episode, we want to talk about family trusts only because the other tools of estate planning, they've been around for quite a while. Many people know a lot about wills. They know a lot about power of attorneys. You may not know the nitty-gritties of it unless you are involved in the process, but many people have an idea about wills, power of attorneys, and what have you. The concept that is newish in Kenya, so to speak, or has become popular in the last couple of years is the concept of trusts, and in this particular case being family trusts. So today we are going to try and talk about Family Trusts 101, basically a crash course for anybody who is interacting with that concept for the very first time, to have a basic understanding of what family trusts are, what they do for people, who can set them up, the process of setting them up, and what have you. So I'm going to ask Wanjiko a couple of questions, and through her answers, you're going to get to understand Family Trusts 101. So let's start. Wanjiko. Again, to somebody who is interacting with this phrase for the first time, what is a family trust?
Okay, I think the first place to start would be what is a trust generally, because there are different types of trust, but for the purposes of this video, we'll be talking about family trusts. So think of a trust as an entity. I think that's a good way to understand, because a lot of us are familiar with entities such as companies. So it's an entity governed by very specific rules. So a trust has three parties. The same way companies have directors and shareholders, trusts also have the parties that are key to the trust being formed. And the number one party is the person who sets up the trust or who creates the trust, who we call a founder. When you talk to a lawyer, you will hear set law. So if you hear set law, it just means the person who sets up the trust. Then the second party is the trustee, who the settlor gives the property and the rules on how to manage their trust. And then the third party is the beneficiary or the beneficiaries. So the beneficiaries are the persons for whom beneficiary benefit, the persons for whom this trust has been set up. It's for their benefit. And to break it down a bit, let me use a real life example. Let me use myself, because I'm in the process of setting up my own trust.
Yay!
Yeah, so I will be the settlor. And then I will appoint a trustee, and we'll talk more about trustees, but for the purposes of my trust, I will be the first trustee. And I can also bring in Wamoyo as a trustee. So that's the second. So there's me, the settlor, then there's Wamoyo, the trustee, and then there are beneficiaries. For me, in my instance, it's my nieces and my nephews. So what I'll do is I'll set up the entity. I will give Wamoyo and myself as the trustees the rules, and I will hand over the property, and I will also give Wamoyo the rules and the regulations of how this property is going to benefit my nieces and nephews. So for instance, I might get a bond, and then I'll tell Wamoyo, when you get a coupon as the trustee, you pay school fees, you provide medical care for my nieces and nephews, and later on when the bond matures and it's time for me to get the payout, maybe reinvest it or just do something with the bond for the benefits of my beneficiaries. So basically that's it. So think of it as it's like a safety deposit box where you put your nice things, and then you give the trustee the instructions for how they're going to take care of that box and how they're going to distribute whatever is in the box to the beneficiaries.
Good. That's a very good explanation. I hope we have not lost you. And I think, thank you for mentioning that you're in the process of setting up a trust, because In many interactions, the only time we've heard about trust, even outside the Kenyan context, is usually with the very high net worth families. The politicians, the Bill Gates of this world, and what have you.
Yeah.
So for you to mention, and I'm not saying that you're not a high net worth individual.
I am not.
But for you to mention that you're in the process of setting up the trust, I think already it's really demystifying who trusts are for.
Yeah.
So now, just in line with that, tell us exactly who is eligible to set up a trust, or who are trusts for. Is it, just break it down. Who can trusts work for? And also you can bring it down to Kenyan context.
That's a very good question, because as you said, for a long time, and especially in our country and in our jurisdiction, trusts have been a preserve for the ultra wealthy, and they have also been a preserve for politicians. So regular mwananchi, they feel like this is an entity that is not for me. And as I said, I am in the process of setting up my trust. And so a trust is for anyone. By law, as long as you're over the age of 18 and you're an adult, you can set up a trust. And trusts are specifically very good for people who, number one, want to protect their assets. So you want to protect your assets from creditors, you want to protect your assets for matrimonial disputes, and we'll talk more about some of these things. Number two, you have beneficiaries. If you have minor children, if you have vulnerable beneficiaries, and by vulnerable beneficiaries, we mean beneficiaries who maybe have special needs and who maybe have physical or mental disabilities and need long-term protection, a family trust is good for you. Number three, if you really don't want to deal with the succession battles, if you don't want to go to court, if you don't want to deal with probate, then you can also set up a trust. Number four is if you're just starting out with investment and you want a vehicle where you can put all of your investments, you want to have them in one basket, then a family trust is also a good thing for you. So all this to say that anyone can set up a trust. Don't sit there thinking, oh, my portfolio is only it's not even 1 million. I'm in the process of building it. Anyone can set up a trust.
Good. Now, you mentioned that one of the parties to a trust is a trustee, and it came out as the person you are entrusting, so to speak, with your assets for the benefit of your beneficiaries. Now, and you also mentioned that as a person setting up the trust, you can be a trustee as well. But who else can be a trustee? Because I think trusts being, my understanding of trust is that trusts have perpetual life. They live beyond the owner of the trust. So who else can be a trustee? Or if I set up a trust and I'm the trustee, if I pass on, how are my roles as the trustee going to be taken up?
Okay, that's a good question. And it's a very good question because trustees are a very key part of a trust. A trustee will they will make or break your trust. That's something we say a lot in our practice. And so, as you've said, ideally, the first person and the first person who should be a trustee is the person who's setting up the trust, because you're the one who understands what your vision is, what are your goals. You're the one who knows what structure you want to create. So we usually advise that as a founder, you are one of the trustees. You can have a co-trustee who is a friend, your spouse. If you have a child who's over the age of 18, they can also be a trustee. And you mentioned, if I pass on and I'm the trustee, who takes over? As you're setting up the trust, you can even think about who is going to succeed me. And we usually call them successor trustees. And successor trustees are important because not only do they succeed you when you die, they can also succeed you if you're incapacitated, which is something that people don't think about. If you're permanently or even temporarily incapacitated, a successor trustee can step in and assist you in the management of your assets and even assist you during that period of incapacity. And even if you don't want to appoint your children as trustees now, because maybe they are minors, they can also succeed you. You can say that when my children turn 18, they can succeed me as trustees.
So beneficiaries can also be trustees?
We actually usually encourage that beneficiaries are trustees, or at least a beneficiary is a trustee because this is their property. This is set up for their benefit. So we will usually recommend that at least a beneficiary or a descendant of the settlor is a trustee. And then we also say, because we say trustee, so here the relationship is a relationship based on trust and good faith. So you need to pick somebody who you trust, somebody if the trust is for your children, someone who your children can be able to go to. You just don't pick somebody who. A question could be, can I leave my children with this person?
Okay.
If you can't leave your children with this person, then they might not be a good choice for a trustee. That is if you're looking in your circles. And then there are people who will talk to me and they will say, only if I don't have anyone in my circle, I can't trust anyone in my circle. And so this is where professional or corporate trustees come in. There are people and entities who offer professional trustee services, of course, as a fee, of course, at a fee, of course. So if you look around in your circle or you feel like there's no beneficiary of mine who I think can succeed me, the option of having a professional trustee is always there.
That's good. Now, you've really broken it down well. What a trust is, who the parties to a trust are, who can form a trust. Now, what is the process?
What is the process?
So after I have internalized and realized that I need a trust, what is the process from the time I decide that I need a trust to the time when now I start reaping the benefits of this trust?
Okay, good question. I think the first place to start, even before we go into the legalities of setting up a trust, estate planning is a deeply personal, deeply intimate process. And so there's this phrase we say, ujiite kamkutano na msikosane kwa hiyo mkutano. So the first place is to sit down with yourself and take stock of your life. So, and by taking stock of your life is asking yourself questions. Number one, what do I own? What are my assets? Number two, what do I owe? What are my liabilities? Number three is, who are my beneficiaries? Who are the people, if I were to die tomorrow, or if I were to die today, would need guidance on how to continue with their life? So who are the people who depend on me? Now, another question you can ask yourself is, what are my goals? What do I want? As we've said, you can use a trust for many things. So what do I want? Do I want to avoid probate? Do I want to protect? Do I want to have generational wealth?
Let me just
chime in.
When I think you have mentioned the word probate a couple of times. For anybody who doesn't understand, what is this probate thing you are avoiding using trust? What is probate, or what is the probate process?
So the probate process is the process whereby, and when we talk about probate, we talk about wills. Specifically, we're talking about wills, which is something a lot of us are familiar with. I don't know whether you want me to take our audience through where there's a will and where there's no will.
I think you can just touch on it.
All right.
Surface, yeah.
So succession in Kenya is governed by the Law of Succession Act. And so there's usually two types of succession. There's testate succession where there's a will, and there's intestate succession where there's no will or no estate plan. So where there's a will, of course, once you draft your will and you appoint your executors and you give instructions, you do need to go to court so that the court can enforce this will.
Okay.
And that's what we call the probate process, where you file an application for a grant of probate. We call it a grant of probate. So when I mention probate, it's that process of, here is my father's will, he passed on. Now I have to go to court so that the court can give powers or can allow the executors to carry out my instructions. Okay. That's the probate process. Because I mentioned intestate succession, where there is no will, you still have to go to court. And here it's usually a bit more complicated because now the court follows what the law of succession says about how property should be inherited.
Okay, so then by having a trust and by passing probate, it means in a family where there's a trust, they do not need to go to court. at all.
Exactly. Especially where property has substantially been transferred into the trust, and this is something we'll talk about in later episodes, you can avoid that headache, that entire headache of, because the headache is not only just going to court, the headache is also, fine, my father left us a piece of property and he said it needs to be distributed this way. Where is the title?
Good.
Or
coming up with the inventory.
The inventory.
You can actually, that's the first battle people that need to go to court for the succession process have to battle with, because where are the titles? Where is this land located?
Exactly.
You know, what bank accounts did this person have? And you can go from one bank to another saying, you know, Ebu, check this ID. Do you have any bank accounts, you know, with this ID number?
Exactly.
So, yeah. So I think if you're saying that by having a trust, you bypass just that whole entire, both probate where there's a will and the non-probate court succession where there's no will, I think you're really introducing to us a really useful tool. So let's go back to now the process. So ulikuwa kwa kamkutano.
Umejiita kamkutano, luckily hamjakosana, so you are taking stock of your life. So you do need to come up with inventory of your assets. You do need to come up with the beneficiaries who are going to benefit from your trust. You do need to think about trustees, and not only in your lifetime, even the trustees who are going to succeed you. The other thing is you do need to think about your goals. What are your goals? Why are you setting up this trust? And once you have this general idea, then now you sit down with your estate planner, and then your estate planner is the one who helps you now come up with the plan. So you go with the raw material, the raw footage, and then they give you now the plan. And so if you're going the trust way, the first thing that your estate planner will say is, we need to draft a trust deed. And a trust deed, we said a trust is like is an entity like the other entities. So companies have articles of association, they have shareholders agreements, trusts have trust deeds. So a trust deed is what will set down the rules and the instructions, and not just the rules and instructions, it will give the name of the trust, it will give the location of the trust, it will give details about the trustees, it will give details about the beneficiaries, it will give details about now it will also give the instructions. This is where the trustees are instructed. This is how you deal with my property as the trustees, and this is how, if there are any distributions, this is how you do the distributions. It will give rules about account keeping, accounting, record keeping. It will also give details about some other offices such as the enforcer, which I think we're going to talk about more in coming videos. So think about the trust deed as just the manual, like the way when you buy a TV, there is a manual for how to use it. So think of the trust deed as a manual. So you sit down, and this process is usually it can take some time because trust deeds are highly custom. So even if you and I, our circumstances, like we even probably have the same portfolio, our dynamics are very different. Our family dynamics are very different. My goals are very different from you. So it's a highly custom process, and you and your estate planner might spend some time there, going back and forth on the terms and the clauses. But once you have the trust deed, then the next step currently is to lodge it with the Registrar of Documents, the Registrar of Documents is a registry where we register documents. I don't know how best to explain it other than that. So you lodge the trust deed with the Registrar of Documents, and then after that, after you've lodged the trust deed with the Registrar of Documents and the trust deed has been registered per the rules of that registry, then now we lodge it for a process called incorporation, and incorporation is what gives the trust legal personality. And right now incorporation is being done by the Registrar of Trusts, who also doubles up as the Registrar of Companies. So this process is done at the Business Registration Service. And then after that, now we go to the process of funding. I think we're going to talk about funding even in more detail in later episodes, but funding essentially is, you have created your safety deposit box. It's beautiful, it has the best trustees, and it has the best rules, but now you need to fill it with properties. So that's the process we call funding, where now you start transferring properties that are in your name, the ones that you want to be held in trust, to the trust, and that's what creates what we hear the trust fund. So when we're talking about the trust fund babies, that's what the fund is. Those properties that you have transferred from your name, and now they're being held in trust by the trustees for the benefit of the beneficiaries. So funding is a really important process as well. So it's a 3-tier process.
Okay, I see. So you've talked about doing the introspection, hiyo ndio ile kamkutano. Doing the introspection, coming up with a trust deed, registering that at the registry of documents, and then incorporating it. Now, we have understood now the process of setup. I've had people being very skeptical about the process of maintaining a trust, right? I've had people, like express that trust are these humongous things to maintain, or they come with all these processes and all these annual costs. What would you say from the moment now you set up the trust, it's fully operational, you have funded it, the trustees now understand what their role is. What does the annual maintenance or the continuous maintenance of a trust look like?
I think to answer that question, and I think why the reason why we have that attitude and we have that idea that trusts are difficult to maintain is because, again, of the myth that we have that trusts are for large estates. And yes, they are for large estates for sure, or they are for the ultra wealthy. And so there comes that thought that this thing is managing so many things, and so it must be very difficult to maintain. And while that's true also, maintenance can also be very easy and straightforward. Because sometimes all like the legal requirements or the legal maintenance that sometimes you go through, number one is, just like with any entity, if you have registered an entity in this country, whether it's a company, whether it's an NGO, there's usually a responsibility to file returns to the registrar. And the purpose of returns is just to inform the registrar, this is the status of the entity. As of now, this is what the entity is called, because sometimes entity change names. So this is what the entity is called. These are the officials. These are the operations. So trust, of course, do have that requirements of filing annual returns with the registrar of companies or the registrar of trust, and that's done by the trustees. So that's one compliance requirement.
How regular is
by
filing?
Annually.
So once every year,
as
just
we call
like
them.
Companies file annual returns for their company.
Exactly. So every year you do have to file annual returns with the registrar of companies, and so it's usually at the anniversary of the setup or of the date of the certificate. So that's one requirement. And then, of course, in the trust deed, there's some rules that, of course, the founder will leave. So some of them would include record keeping. Of course, you do want to keep good records for the trust, for sure. You might have some responsibilities, like, you do need an accountant to come and look at the books. Like, what is the trust looking like right now? What are our books like? What are our assets? Of course, then there's the issue of distribution. That's also something that that is just in the day-to-day running of the trust. You do need to make distributions to beneficiaries. And sometimes when people tell me, oh, now we have this structure, we have this rule, we have this rigidity. And my question usually is, you would still be doing these things anyways. You would still be paying school fees. You would still be paying medical. You would still be taking
And while
medical.
on that, let me ask you, can people trade using their trust? Like, can they run supermarkets?
That's a very good question, actually, which also helps with this maintenance conversation. So in Kenya, trusts, their purpose is wealth preservation, succession planning, and wealth management. So you can't use a family trust to trade. So you can't trade. So if my trust is called Olive Wanjiku Mushoki Family Trust, I cannot now go and open a supermarket and start trading with Olive Wanjiku Mushoki Family Trust. So what we usually do is we'll if the estate has some trading aspects, then we usually lay it with the company, and the company does the trading, and it does the it complies with the requirements of trading under a company, but the trust does not do any trading.
Okay.
So that also reduces a lot of the maintenance costs. So for instance, if your family trust is just holding assets, it's holding property, it's holding financial assets, and it's not doing any kind of trading, then also the maintenance is still very basic, right?
Okay.
And then of course there's tax compliance. So the same way all entities have to comply with tax, and tax is a conversation we're also going to have specifically in future episodes, but also there's the tax compliance aspects. The same way as an individual you have to file returns is the same way a trust has to file returns with KRA and comply with the requirements of KRA. So those are some of the maintenance required.
You mentioned the process of setting up a trust, the process of maintaining a trust. Would you tell us what the approximate costs are when it comes to setting up a trust? In as much details that you are able to tell.
Okay, so the costs, first of all, are, I know every time you ask a lawyer, they say it depends. And people are very frustrated by that answer.
but I'm still going to depend.
I'm still going to answer it like that. Yeah. It depends. Because first of all, with the setting up of the family trust, of course, there are professional fees. You do need to pay your estate planner, of course. So the professional fees vary from advocate to advocate or from estate planner to estate planner. And some of the reasons why it would vary is, first of all, your family dynamics. Of course, if your family dynamics are complex, you have perhaps a polygamous family or you have a blended family, and there's a lot of thinking that the estate planner has to do. There's a lot of structuring that the estate planner has to do. Of course, the costs are going to be higher than if it is just me who is setting up a trust myself. The other thing is also dependent on the estate. How big is your estate, or how big is the trust fund? So that's also another reason why it depends.
Okay.
But then the government costs, maybe that's something I can touch on.
You can detail what the other costs. Away from the lawyer, of course, the cost now will depend which lawyer do you
go to?
How, how do they price themselves, right?
Yeah.
But the other costs that remain constant, maybe you can tell us what those costs are.
So the constant costs at the registry of documents. I think right now it's 1,000 bob. I want to be very cautious with that.
I think it's 1,000 bob.
1,000 bob. And then, of course, there's a nominal stamp duty. 240 Kenya shillings.
Between 240 and 280.
Exactly. Yeah. So there's the nominal stamp duty. And of course, there's what did we say? The registration fee at the Register of Documents. And then with the business registration service, I think at this point it's Kenya shillings 10,000.
Yeah, it's 10,000, and that's what they call the convenience fee. The citizen
convenience fee.
Yeah,
there's that. I think, and then now the cost of funding. For instance, if you're transferring property to a piece of land from your name to the name of a trust, of course there are those attendant costs at the registry. And I think something that people worry about is, if I go to a lawyer, they are going to quote they will quote a huge amount.
Yeah.
And while that may be true, the thing you need to ask yourself, and the balancing here is, if I pay this fee that the lawyer is asking for me right now, and compare with the pain and the inconvenience of succession, if you don't do this, if you don't set up the trust right now, the cost later is usually so much higher than this investment that you're making. I think it was yesterday you were telling me about this lawyer who is asking for 120 million in a succession case.
Yeah.
So that's the balancing act you need to do. It might look like a big investment right now, but think of this is a long-term thing. This is protection over a long term. And trust me, if you come to me with a succession case and it's convoluted, okay, not me, but lawyers they will not hesitate to charge you fees. And an estate might be depleted at the point of succession because of the high legal fees.
Okay. So now we've gone through that whole process, the process of setup, what maintenance of a trust looks like, and all that. Now, in very just highlight for us, what are the advantages of family trust? Just the highlights. I know we'll get deeper into those advantages in subsequent episodes, but just mention to us a couple
Quickly.
of those advantages of, setting up trusts.
Okay. I think let me start first of all with wealth protection, wealth preservation, and wealth consolidation. So wealth protection is protection from creditors, protection from matrimonial disputes. Then with wealth consolidation is having all of rather than having what you own scattered in very different types of ownership, you have them owned in one vehicle. And also wealth preservation in the sense of sometimes when you don't leave instructions, you can find that what you own has been subdivided, like land. It has been subdivided into so many pieces that are not even helpful in the long run.
Viable.
Yeah, economically viable. You can't even sell it because it's so tiny. So if you put your wealth in one vehicle, you can be able to protect it, preserve it, and also consolidate it. Number 2 is long-term protection for beneficiaries. So minors, and as we said, vulnerable beneficiaries. So if you have a child who is a vulnerable beneficiary or any other kind of beneficiary who is vulnerable, you can set up a process of protecting them long term. Number 3 is avoiding court, whether probate, whether testate or intestate succession. As we've said, it's kind of it's a headache. So
it is a headache.
It is a headache. So if you can be able to avoid that through a trust, then yeah, why not? Number 4, we can say privacy, because whether you have a will or not, succession is usually a public ordeal. Your will becomes a public document.
We've gotten to know people's private affairs just by the fact that they've died and their wills are now in court, and the media gets access to them,
right?
And suddenly we know all your business.
We know all of your business. So if privacy is very important to you and you want to keep your family affairs private, then of course you can use a trust for that purpose. And I think we'll talk about other advantages in depth. But for now, those are some of the things that I would say, if you're considering, then maybe this is why you should go ahead.
Okay, one last question. You have vouched for family trust very, very well, right? Such that many people now probably considering, that idea. But we've heard, or many people have heard about the Njenga Karume Trust, and not in very positive light. Many people are aware that at some point, Njenga Karume set up a trust, and at some point it was embattled, and there was a court case. And so if trusts are this good, the way you're putting it, if these trusts are such useful tools, and they are meant to avoid all these disputes and what have you, how comes the Njenga Karume Trust ended up in court? And what can people do? Of course, in very broad, in a very, you can summarize it. What can people do to avoid setting up trusts that go the Njenga Karume way? Yes. And also you can tell us what worked and what did not work. In very,
very short.
Yes.
Yeah. I think to answer that question is to acknowledge that human beings are flawed.
Yes.
And a trust relies deeply on human beings. And the human beings that we are talking about here, unless you go the corporate trustee way, and even that is not a guarantee.
It's still humans behind
the corporate. But specifically when trustees are natural persons, they're human beings, and they're flawed, and they're prone to temptation and all kinds of things that are natural to the human condition. And so one of the problem with the Njenga Karume Trust was that the trustees, the people who are left to, who are given these instructions and who are left to manage this trust, of course, they were flawed human beings.
Okay.
And so, as we said earlier, trustees can make or break your trust.
Ah, okay.
So trustees sometimes are a big thing for why trusts will fail. And which is why we said you have to be, when we're talking to clients, we tell them, don't make this decision lightly. Think about it. Think about it deeply. This person, can I trust them? Can I, if I were to die tomorrow, do I know that they will have my best interest at heart? Will they have the best interests of my beneficiaries? So trustees is a big thing why trusts fail. Some other ways would be poor structuring or not having, and another reason also is lack of accountability. So you give human beings who are flawed a responsibility, and you do not give them an accountability mechanism.
Okay.
So they, first of all, you don't provide for, like in the Njenga Karume case, I think beneficiaries were not even allowed to even have access to the records of the trust or the accounts. So if you fail to give the trustees an accountability mechanism, then they run amok. Yeah, and they do what they want.
Okay, so there are things you do for your trust.
Yes.
To sort of safeguard some of those things that led to the disputes that came up with the Njenga Karume Trust.
Exactly, and accountability is a big one. And also just allowing the beneficiaries to have a say. Fine, they might not be running the trust, but can they access the books of the trust? Another thing is, when we'll talk about it more, is the office of the enforcer.
Okay.
Yeah, so the enforcer is the person who watches, who oversees the actions of the trustees and make sure that the trustees are acting according to the manual that you left them.
Okay.
But then to answer your question, yeah, fine, okay, trusts, you have given a flawed human being a responsibility and now your trust is in trouble. Courts, and as like the Njenga Karume case, it ended up in court. Courts are very... They're very keen not to undo the intention of the creator of the trust.
Okay.
What courts will do is they will fix what's not working, because the intention, like in the Njenga Karume Trust, what wasn't working was the trustees. So that the court said the trust remains, but the trustees go. So whatever is not working is what is going to be fixed by the court. It is very unlikely that the court will, unless it doesn't meet the requirements of a trust. But if it's because there's something that's not working in the trust, maybe there's a clause that's not working, get rid of the clause.
And get the trust back.
And get the trust back in.
Okay. So what I'm getting from you is setting up, you don't set up a trust just for the sake of setting up a trust. You have to be very careful with what kind of safeguards you're putting in that trust, what kind of individuals you're entrusting them, and within what boundaries are those individuals operating. And if they go wrong, like it happened with the Njenga Karume case, there's recourse for the beneficiaries to ensure that things are able to go back on track.
Exactly.
Okay, my questions end there. If you have watched up to this minute, thank you very, very, very much. We really appreciate. I hope this episode was of value. Of course, we are going to break down further some of the things that we have just touched on in this episode in the subsequent episodes. But thank you very, very much for sticking around. And please do subscribe to this channel. Share this information with your friends, with your family. And let's meet here in maybe 1 or 2 weeks. Bye-bye.
Bye.